Assalamu alaikum, students. Okay, in this lecture, this is the third part of the previous lecture, as we are discussing regarding the establishment, the structure, and the jurisdiction of the International Criminal Court. Here is the second session of our lecture, and these are the topics which we are going to discuss in our this session. The ICC jurisdiction. How does the ICC operate, the structure and organization, and ICC members states, and finally, in last part, we are going to discuss two illustrative cases. So I'm going to start my lecture, students, because this is very much important part of the lecture, and now you have to understand how ICC International Criminal Court will take the cognizance of the offences which will come in the ambit of the jurisdiction of the ICC. And the students, the ICC jurisdiction, when they prosecute individuals or states, there are these are the type of subject matter jurisdiction which take the cognizance of the crime of the genocide, crime against the humanity, and the war crimes, and the crime against the aggression, which is the article number 5 of the Rome Statute. The most insidious crimes which shock the human minds and human brains. First, crime within the jurisdiction of the ICC. So, which crimes fall within the jurisdiction of the ICC? The mandate of the court is to try individuals rather than states, and to hold such persons accountable for the most serious crimes of the concerns to the international community as a whole. So, which are the crime of the genocide, war crimes, crime against humanity, and the crime of the aggression, when the condition for the exercise of the court's jurisdiction over the latter are fulfilled. So one by one, I'm giving you the brief introduction of those crimes, because after the midterm, we are going to discuss in detail of those crimes, their nature, their gravity, and the situation, the circumstances on which the state responsibility and the ICC responsibility we will discuss. So very quickly, I'm giving you the thorough and brief overview of those crimes. The first category of crime, that is the genocide. According to the Rome Statute, genocide means any of the following acts committed with the intent to destroy in whole or in part national, ethnical, racial, or religious groups, killing of members of those groups, causing serious bodily and mental harm to the member of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destructions in a whole or in a part, imposing measures intended to prevent births within the group, and forcibly transforming children of the group to another group. These are the ingredients and conditions regarding the genocide crime. Next is the crime against the humanity. Crime against humanity includes any of the following acts committed as part of the widespread or systematic attack directed against any civilian population within the knowledge of the attack: murder, extermination, enslavement, deportation or forcible transfer of the population, imprisonment, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of the comparable gravity. Prosecution against an identifiable group on political, racial, national, ethnic, cultural, religious, or gender grounds. Enforce disappearance of persons, uh, the crime of on the basis of the religious and gender grounds, other inhuman acts of the similar character, intentionally causing great suffering or serious bodily or mental injury. So next category is the war crimes. War crimes includes grave breaches of the Geneva Convention and the other serious violation of the laws and the custom applicable in the international armed conflict and in conflicts not of an international character listed in Rome Statute. When they are committed as part of the plan or policy or on a large scale, these prohibited acts include murder, mutilation, cruel treatment, and torture, taking of hostages, intentionally directing attacks against the civilian population, intentionally directing attacks against the buildings dedicated to religious, education, arts, science, or charitable purpose, historical monuments, or hospitals, pillaging, rape, sexual slavery, forced pregnancy, or any other form of the sexual violence. Enlisting children under the age of the 15 years into the armed forces or group, using them to participate actively in hostilities. So next, uh, category is the aggression, the crime of the aggression, is adopted by the Assembly of the State Parties during the review conference of the Rome Institute held in Uganda between 31st or 11th June 2010. As a crime of aggression means the planning, preparation, initiation, or execution of an act of the using armed force by a state against the sovereignty, territorial integrity, or political independence of another state. The act of aggression includes, among other things, invasion, military occupation, and annexion by the use of the force, blockade of the ports or courts, if it is considered being by its character, gravity, and scale a manifest violation of the Charter of the United Nations. The perpetrator of the act of the aggression is person who is in a position effectively to exercise control over or to direct the political or military action of a state. When will the when will the court have a jurisdiction over the crime of aggression? The court may exercise jurisdiction over the crime of the aggression subject to the decision to be taken after 1st January 2017 by a two-third majority of the state parties and subject to the ratification of the amendment concerning this crime by at least 30 state parties. And under what? The question is that under which condition would the court be able to exercise its jurisdiction over the crime of aggression? The court will be able to exercise jurisdiction over a crime of aggression arising from an act of the aggression committed by the state party unless that state party has previously declared that it does not accept such jurisdiction, except when situation is referred to the court by the United Nations Security Council. The court has no jurisdiction over crimes of aggression committed in the territory of the state which is not party to the Rome Statute or by its citizen. The court will have a jurisdiction only over crimes of aggression committed 1 year after 30 states parties ratify or accept the amendments of the Rome Statute in relation within the crime of aggression, which were adopted by the Assembly of the State Parties in June 2010. So, how would an investigation into a crime of aggression is be opened? If the United Nations Security Council determines that an act of the aggression has been committed, the ICC prosecutor can decide to open an investigation under the conditions mentioned above. Otherwise, the prosecution may examine the situation and, based on its assessment, may notify the United Nations Secretary General of the situation. If within the 6 months of being notified by the prosecution, the United Nations Security Council does not make a determination on the whether or not an act of aggression has been committed, the prosecutor may still proceed with an investigation into a crime of aggression, subject to the authorization by the ICC's pretrial division. Students, here's our next topic of the today's lecture is that the structure and organization of the ICC. As earlier, I gave you thorough brief. There are four organs of the ICC. So I'm giving you a very thorough and brief introduction of each part of this structure and organization. So the students, the structure of the the ICC is composed of the four organs: the presidency, the chambers, and the office of the prosecutor and the registry. Each of these organs has a specific role and mandate. The first I'm start from the what presidency do. The presidency consists of three judges, the president and two vice presidents, elected by an absolute majority of the 18 judges of the court for a maximum of the 2 or 3 years terms. The presidency is responsible for the administration of the court, with the exception of the office of the prosecutor. It represents the court to the outside world and helps with the organization of the work of the judges. The presidency is also responsible for carrying out other tasks, such as ensuring the enforcement of the sentences imposed by the court. Next organ, students, the chambers, and what do the chambers do? The 18 judges, including the three judges of the presidency, are assigned to the court's three judicial divisions. The pre-trial division, composed of 7 judges, the trial division, composed of the 6 judges, and the appeals division, composed of the 5 judges. They are assigned to the following chambers. The pre-trial chambers, each composed of 1 or 3 judges. The trial chambers, each composed of the 3 judges, and the appeal chambers, composed of the 5 judges of the appeal division. The roles and responsibilities of the judges are outlined by category of the pre-trial, trial, and appeals chambers. So, actually, chamber where there are 3 stages of the chambers: pre-trial, trial, and appeals. So each division is consists of the composition of the each division, which consists of the judges by their selection, and how this selection should made. How are the judges elected? The judges are persons of the high moral character, impartiality, and integrity, who possess the qualifications required in their respective states for the appointment to the highest judicial offices. All have extensive experience relevant to the court's judicial activity. The judges are elected by the assembly of the state parties on the basis of their established competence in criminal law and procedure and relevant areas of the international law, such as international humanitarian law and law of the human rights. They have extensive expertise on the specific issues such as violence against the women or children. The election of the judges takes into account the need for the representation of the principal legal system of the world, a fair representation of the men and women, and equitable geographical distribution. The judges ensure the fairness and proceedings and the proper administration of the justice. So, as I mentioned, there are the three division. The first division of the chamber, the role of the pre-trial chambers. The pre-trial chamber, each of which is composed of either 1 or 3 judges, resolve all issues which arise before the trial phase begins. It is the initial stage of the trial. Their role is essentially to supervise how the office of the prosecutor carries out its investigatory and prosecutorial activities to guarantee the rights of the suspects, victims, and witnesses during the investigatory phase. And to ensure the integrity of the proceedings, the pretrial chambers then decide whether or not to issue a warrants of the arrest or summons to appear at the office of the prosecutors request, and whether or not to confirm the charges against a person suspect of the crime. They may also decide on the admissibility of the situations and cases and on the participation of the victims at the pre-trial stage. So next stage, that is the trial stage, and what is the role of the trial chambers? Once an arrest warrant is issued, the alleged perpetrator arrest and the charges confirmed by a pre-trial chamber. The Presidency constitutes a trial chamber composed of 3 judges to try the case. The trial chamber's primary function is to ensure that trials are fair and expeditious and are conducted with the full respect for the rights of accused and due regard for the protection of the victims and the witnesses. It also rules on the participation of the victims at the trial stage. The trial chamber determines whether an accused is innocent or guilty of the charge, and if he or she is found guilty, may impose a sentence of imprisonment for the specified number of the years, not exceeding a maximum 30 years or life imprisonment. Financial penalties may also be imposed. A trial chamber may thus order a convicted person to make reparations for the harm suffered by the victims, including compensation, restitution, and rehabilitation. Next, students, the stage that is the appeals. The appeals. The main function of the appeals chamber. The appeals chamber is composed of the president and the court. And the 4 other judges. All parties to the trial may appeal or seek leave to appeal a decision of the pre-trial and trial chambers. The appeal chamber may uphold, reverse, or amend the decision appealed from, including judgments and sentencing decision, and may even order a new trial before a different trial chamber. It may also revise a final judgment or conviction or sentence. Now, next, the next organ, that is the Office of the Prosecutor. What does the Office of the Prosecutor do? The Office of the Prosecutor is an independent organ of the court. Its mandate is to receive and analyze information on the situation or alleged crimes within the jurisdiction of the ICC, to analyze situation referred to it in order to determine whether there is a reasonable basis to initiate an investigation into a crime of genocide, crime against the humanity, war crimes, or the crime of the aggression, and to bring the perpetrators of these crimes before the court. So last organ, that is the registry. Students, what does the registry do? The registry helps the court to conduct fair, impartial, and public trials. The core function of the registry is to provide administrative and operational support to the chambers and the Office of the Prosecutor. It also supports the registrar activities in relation to the defense, victims, communication, and security matters. It ensures that the court is properly served and develop effective mechanism for the assisting victims, witnesses, and therefore defense in order to safeguard their rights under the Rome Statute and the rules of the procedure and evidence. As the court official channel of the communication, the registry also has a primary responsibility for the ICC's public information and outreach activities. So, students, it was the brief introduction of the this whole structure of the ICC. So each organ, I gave the very precise introduction of each organ of the ICC. I hope that